This video is for informational purposes. It is not legal advice. You should contact your local Citizens Advice to get help with your particular issue or problem. To find your local Citizen Advice, visit www.citizensadvice.org.uk. Hello, Adam from Citizens Advice East End here again. Welcome to the fifth of our videos about employment rights and the final of our 3 on dismissal. If you've not watched our 2 previous videos on dismissals, we would strongly recommend that you do so, as otherwise you may find this video a little difficult to follow. Let's briefly recap what we discussed before in the first and second videos. You must be an employee and have worked for 2 years' service before you can challenge a dismissal. There are 5 fair reasons for an employer to dismiss and 5 basic elements to any fair process. There are some narrow exceptions to that 2-year rule. The fairness of the dismissal procedure will depend on the reason being relied upon by the employer. In this third and final video on dismissals, we will be covering the following: the process to be followed in a fair redundancy, dismissals for some other substantial reason, aka SOSR dismissals, entitlement to and calculation of statutory redundancy pay, and finally, constructive and fair dismissals, that is, where you are forced to resign. Turning then to fair redundancy processes. Redundancy is where one or several people's jobs are no longer required at an employer's organisation. It is not to be confused with retirement or if you are too ill to work. The basic process is as follows. First, the employer should inform those at risk of redundancy that they might be made redundant. An employer should do so as far in advance as possible, although for redundancies affecting under 20 people, 1 month is usually considered enough. Please note, notifying you that you are at risk of redundancy is not the same thing as minimum notice of dismissal. Those at risk form the selection pool. A selection pool can be as small as 1 individual, but he or she still needs to be told that his or her job is at risk. Second, to see who will remain from the pool, invite everyone in the pool to a meeting and discuss their appropriateness for selection for redundancy. When doing so, employers must apply objective criteria for selection during these meetings. If there is only one type of role, and only one person performing that role that makes up the selection pool, the redundancy may be inevitable, and as such, this meeting may not occur at all. Third, appropriate action should be taken. If an employee has been selected for redundancy, any other appropriate role should be offered if available. Finally, you can always appeal a redundancy, like any other dismissal decision. However, in many redundancies, it is relatively straightforward for an employer to show it has followed a fair process, and thus there will be few, if any, grounds of appeal. Just a couple of other things to bear in mind regarding redundancy before we move on. The first thing is, how long the employer has to notify of the risk of redundancy will generally depend on the numbers of people at risk of redundancy. That is, the greater the number, the longer the notice period. In addition to this, there are specific requirements on employers for there to be additional consultations with redundancies involving over 20 people, as well as further consultations on top of this with those involving over 100 people. Secondly, where there are individual consultation meetings, where you are marked with set criteria, say timekeeping or relationship with your colleagues or attitudes towards your work generally, you cannot normally challenge how you are marked in relation to said criteria. For example, if your employer marks you down for being late, but you know you were never late in your life, it doesn't matter, you can't object to it. The only time where this isn't true is if the criteria are not objective, so for example, you're marked down for having the wrong hair colour when this has nothing to do with your job, or the criteria, or way in which they are applied, represent a detriment or are potentially discriminatory. We will be dealing with these sorts of claims in other future videos. If you are made redundant, as long as you have been employed for 2 years, you'll be entitled to at least statutory redundancy pay. Statutory redundancy pay is only paid for complete year's service. So you will be paid 1 week of your gross pay, that is pay before tax is deducted, for each complete year of your employment. Your gross pay is capped, however, As of 6th of April 2021, this statutory cap is £544 per week. However, this is increased every tax year. If you earn above this amount and you are only entitled to statutory redundancy pay, you will not be paid any more above this figure for your weekly gross pay. This is in turn multiplied by an age factor dating back from how old you are when you are made redundant. This age factor or age multiplier is 0.5, that is half a week, for years worked when you were between 18 and 22 years old, 1.0, so a full week, for years worked when you were between 22 and 40 years old, and 1.5, so an extra half week, for years worked when you were over 41 years old. This is, of course, only your minimum entitlement. As always, check your contract if you have one in writing, and you may have a larger entitlement over and above your statutory redundancy pay entitlement. This is called contractual redundancy pay. Some other substantial reason, or SOSR dismissals, can come up in theory at any time when an employer believes it has a reason to dismiss other than the previous four reasons. Just as a reminder, that is conduct, capability, legality and redundancy. However, it arguably most frequently comes up in company restructuring. This is because as an alternative, or sometimes in addition to making staff redundant, employers may decide to change people's contracts. Often this is to retain staff while reducing costs by things such as creating job shares or asking staff to go part-time from full-time or vice versa. This can be by merging roles, reducing hours, or renegotiating hours. There are a limited number of legal ways, however, that your contract can be changed. The important thing to understand, so that you can recognise a potential SOSR dismissal, is that you're only redundant if your role no longer exists, not if your contract is simply renegotiated. Always, therefore, seek advice in such situations before you accept or refuse any offer. You will not be entitled to statutory redundancy pay in an SOSR dismissal, for example. An employer must, however, still follow the ACAS 5 keys to a fair dismissal process, with the most important being to inform the employee of the issue. For example, a loss of business may mean that wages or hours have to be reduced, as there is not enough money to pay staff at their current salaries. Employers must be transparent about this fact, as well as any proposed solution to it, with their members of staff. Any lack of clarity may suggest that an SOSR dismissal is not being fairly carried out. Finally, then, we are going to discuss the situation where your contract isn't terminated by your employer, but where you are forced to leave. This, potentially, might constitute what is called a constructive unfair dismissal, what often are inaccurately called constructive dismissals. Please note, making this claim is not easy. We would strongly suggest you treat with extreme skepticism anyone who says you can just, in air quotations, resign and claim constructive dismissal, again, in air quotations. Firstly, you need to be employed for 2 years before you can claim. There are no exceptions to this rule. Secondly, constructive unfair dismissals are the exception, not the rule. They are difficult to prove because in order to succeed at tribunal, you need to show that, first, you have resigned. That is, that you have clearly and unambiguously decided to terminate your contract. The best way to demonstrate this is to provide a resignation letter sent by email or via recorded post. Second, that this resignation is in response to a breach of contract, that is, some sort of wrongdoing by your employer, say a failure to pay your wages or a failure to deal with a persistent bully at work. This is often the most difficult part to show, and where most claims fail. People will take time to consider leaving their jobs. This is understandable. Unfortunately, it means there is often a big gap between when there is a breach and when there is a resignation. Third, that the breach you are resigning in response to is a fundamental breach of contract. This is fact dependent, but broadly speaking, you need to see if the breach goes to the heart of your contract. In simple terms, is your employer's behaviour so unbearable that you actually are unable to do your job and that you have to resign? For example, failing to deal with a bully, probably yes. Taking away your complimentary gym membership you never used, probably not, unless you actually work at a gym. It is from these that you can construct a dismissal from what is ordinarily going to be a resignation. But these three things are hard to show at once, so we would recommend that you at the very least provide a resignation letter, if not raise a complaint about the behaviour you are complaining about before you resign. Whilst these are not a legal requirement as such, they make it much easier to evidence or prove your case at an employment tribunal. What also might help to show your resignation is in response to a fundamental breach of contract is if you resign without notice. You can, as an additional and alternative to constructive unfair dismissal, claim for any notice period you are now unable to work because of having been forced to leave. This is what is called a constructive wrongful dismissal. This is why constructive dismissal is an inaccurate term, because it would mean either an unfair dismissal, that is challenging being forced to leave, or wrongful, that is only challenging your employer for your notice pay. If, however, you don't prove it was a constructive wrongful dismissal, then this is technically a breach of contract on your part. As such, this is always an extreme step, and you should always seek advice before resigning if you have time to do so. Once again, and for the final time with dismissals, for the takeaways, and in this video we have spoken about, firstly, that redundancies are hard to challenge, as it is rare that you will have the evidence to show the redundancy situation, that is, the company is restructuring or becoming insolvent, is false. In addition, to show a fair process, it only needs to show that it notified you of the risk of redundancy. Whilst this changes depending on whether it is over 20 or over 100 people being made redundant, for which there are additional consultations, for fewer than 20, generally 1 month's notice is sufficient. That objective criteria were applied in selecting you for redundancy. You can't challenge the application of these criteria unless you can show the application represented a detriment or were discriminatory. These are covered, as we stated before, in further videos. That your employer offered suitable alternative employment. Sometimes if the company is small and is shutting down altogether, this just won't be possible. Secondly, that if you are made redundant after 2 years service, you will be entitled to statutory redundancy pay. You should, particularly if you're made redundant before 2 years service, make sure you check your contract for any additional entitlement to redundancy pay. Thirdly, that you will not receive redundancy pay if you are dismissed for some other substantial reason. This can have all the signs of being made redundant, as it will often involve a suggested change to your contract further to an organisational restructuring, including other people being made redundant. Always seek advice, therefore, before rejecting any amendments to your contract. Finally, if you are forced to resign and have been employed for 2 years, this may constitute a constructive, unfair dismissal. These are hard to prove, and you should, if you can, seek advice before resigning. So at the end of these 3 videos on dismissals, what have we learned? We learned that you can normally only challenge dismissals once you've been employed for 2 years. We learned that whilst there are exceptions to this rule, they are difficult to prove. We also learned that if you have been employed for 2 years, you can only successfully challenge a dismissal if your employer is unable to show that there was a fair reason to dismiss, and that there was a fair process followed in dismissing you. There are 5 fair reasons to dismiss and 5 keys to a fair process, with the reason given shaping how that process fits within those 5 keys. Finally, we learned that if you have been forced to resign, in some limited circumstances you might be able to show that this constitutes a dismissal. We hope you found this video useful. Our next video will be concerning wages and holiday pay.